All right, Chris.
Okay, well, thanks to everyone, especially the Mikes, for a chance to comment, and to Mike again, and to John for a very rich paper. I really agree with an awful lot of what they have to say, and I'm not sure how important our areas of disagreement are. If John and Mike accept some of my comments as friendly amendments, it would make me feel good in one sense. Agreement is always nice, but not in another, since it's my job as a commenter to land some punches where it hurts. I generally really like the first section, especially why an intended uptake view needn't compete with original methods. Not sure about the dresser table hypo in footnote 4, but no time for that. I really like the second section as well, about legal language. Lay people looking at the Constitution would, I think, defer to lawyers in interpreting it. Lawyers act as the linguistic agents of the rest of the population. Qui facit per alium facit per se. He who acts through an agent acts himself. Linguistic division of labor is a big thing, for what it's worth, among certain philosophers of language like Hilary Putnam, Tyler Burge, and Saul Kripke, and their followers in the last 40 or 50 years. It was the new theory of reference, but it's getting a little old. When ordinary people say molybdenum, they mean whatever scientists mean by molybdenum. And when they say in the Constitution ex post facto, they mean whatever lawyers mean by ex post facto. Getting our philosophy of language clear here will be important for part 3 on determining interpretive rules, because clarity on what interpretive rules are will affect how we find them. What are we talking about when we talk about an interpretive rule? What is the truth maker for interpretive rule claims? At pages 26 to 29, we do get some theoretical exploration of what an interpretive rule is, and at pages 29 to 30, some talk about what we need to have a language, but there are a lot of tricky philosophical waters nearby. David Lewis's 1969 book, Convention, and 1975 paper, Language and Languages, might be a good starting point, as well as the new theory of reference people. If Lewis's account is wrong, I'd like to know how it's wrong. Seems to me that what we're looking for when we're looking for an interpretive rule is a late 18th century sociological phenomenon among lawyers. We're looking for the existence of linguistic conventions in something like David Lewis's sense. Focal points that everybody in a population is in a position to know about, and in a position to know about everyone's being in a position to know about, etc. If linguistic conventions are a sociological phenomenon, what is the best way to figure out what those conventions were? The best way to understand what was really going on among late 18th century lawyers? Well, one way would be to look to see if late 18th century lawyers said anything about those sociological realities of language use. That would be the original meta-methods approach, I think. But another way would be to try to do it ourselves, to construct elaborate databases to see what extent, for instance, lawyers drafting contracts use redundant language or treat preambles as restrictive rather than merely clarifying or obey expressio unius. In principle, big data might help us understand a language even better than its practitioners. I've spent more than a year, for instance, thinking about what happened in 1866. The people of 1866 only spent a year. If that's right, we should be looking for the original rules for attaching meaning to particular marks, but not necessarily the original meta-rules. The founders were mistaken about things like the relative populations of Maryland and North Carolina, as we learn from Article 1, Section 2, Clause 3. Likewise, they could, in principle, be mistaken about the relative populations of lawyers who use conflicting canons or conventions. Original meta-rules aren't themselves binding. Seems to me even clearer that we also wouldn't want to use the founders' meta-meta rules, That is, their methods for determining what courts say about what the canons of interpretation are. Footnote 52 at page 39 mentions Holmes, a 1780 New Jersey case, which didn't even release an opinion. In a world without regular judicial opinions, most lawyers would determine the existence of principles of law enunciated by courts by talking to people who were in the court at the time. Knowing literally unwritten law is quite different from doing history with written sources. We can't use the original meta-meta methods, I think. Also, I want to push back on the universality of the 5149 preponderance of evidence meta rule. There are some settings in which that would be right, but others where it wouldn't be. In the context of judicial review, I think, and John thinks too, judicial power is only the power to refuse to enforce a statute if the statute is clearly, not merely probably, unconstitutional. But a case might turn entirely on the existence of an interpretive canon. Imagine a right uncontroversially within an operative clause, but outside the preamble. So the only question is whether we want to use something like cessante ratione legis, cessat ipsa lex. I'm not a Latin pronouncer of any particular skill. The rationale for the law ceasing, the law itself ceases, something like that. Or instead, the Heller interpretation of Coatman from 1716. If we only have a 51% confidence about the canon, but everything else is undisputed, we only have a 51% confidence about our ultimate conclusion, and that's not enough for judicial review. No early court adopts a preponderance standard for judicial review. Indeed, no court from any state at any time. Every court to address the issue, including courts from all 50 states, say constitutional conflicts must be clear. Footnote 159 indicates some Rappaportian skepticism about this point. But I can't see why this disagreement is beside the point, as the paper says. If it's possible for a case to turn entirely on a single canon, and it certainly seems that it could, there's no general 5149 meta rule. In addition to being a problem for the 5149 meta rule, this example is also a case where different meta rules produce different results, undermining the all roads lead to Rome strategy for answering the infinite regress argument. Meta rule disagreement matters, and meta-meta rules aren't a good way to resolve it. If we don't have a good way to end the regress, best not to get it started. The existence or non-existence of a clarity requirement for judicial review also affects how we deal with vagueness, specifically unclear boundary cases. Rights, powers, and structures generally have boundaries that are not absolutely clear, but fuzzy. John Steniford's stuff on cruel is talking about two different standards, but they, I think, clearly have fuzzy boundaries, either of them. So in the context of judicial review, what do we do with a right with a fuzzy boundary? Well, we've got a clearly unconstitutional zone, a clearly constitutional zone, and an unclear zone in the middle. If we have a clarity requirement for judicial review, we stop enforcing a right once it starts getting fuzzy. The beginning of the fuzzy zone is the end of judicial review. But a 5149 interpreter would say, keep enforcing it until the preponderance shifts. Enforcement stops not at the edge of the fuzzy zone, but somewhere in the middle. As long as there are a better than even chance that a constitutional right is being violated, that's enough. But note well, and this is something that Naomi's comment on the Bode Sachs paper picked up on. A clarity rule for judicial review is not a rule of interpretation, because different interpreters reading the very same provision in a different context, a legislature deciding whether to pass such legislation in the first place, for instance, would use a different rule. Legislatures would use at least a 5149 rule, or perhaps even avoiding infringing rights unless it's clearly constitutional. Again, I'm not sure how big a deal this is. At footnote 120, talking about non-interpretive rules of precedent, the paper indicates some flexibility about what does or doesn't get placed in the interpretive bin, But it seems to me evidence quantity rules have got to be non-interpretive. The 5149 meta rule is itself a rule of construction, not interpretation.
Stop.
I'm done.
Perfect timing. Mike and John, your response.
So we'll divide this up. So thanks so much, Chris, for that. So one point you made is in figuring out the interpretive rules, is it what they said or what they did that actually matters if the two disagreed with one another? And that's a very good question. I'm not entirely sure what the answer is. I would generally say that what they said and what they did would go together. In cases where they are different from one another, one wants to know sort of why they are different. Were people just paying lip service for something that everyone kind of knew they weren't doing? Were people subconsciously not doing something because for subconscious reasons they really weren't in agreement with it, but they weren't aware of that fact? So it's a difficult matter. It probably depends on the particular circumstances. It also depends if we're in the reasonable, in the original public meaning version versus the original intent version. Here, so the question would be what a reasonable and informed person would want to be doing, would be doing in that circumstance, and if everyone said it and people weren't aware they weren't doing the thing, then I would think that would be actually what the rule was, even though people weren't actually following it, but other people wouldn't have known about that. So it's a great question. I certainly need to think more about it, but I think there are, that's at least, some of the answer that we can give here. I wasn't with respect to meta rules in general, the fact that we won't always know what they are doesn't mean that in situations that where we do know, we can try. We've always got a difficult situation of trying to figure out the best that we can what's going on here. So I don't think you can draw the conclusion, well, if we don't have perfect information here, we can't use this. If we don't, we've got some information. We make our best guesses as to these matters. Again, there's a kind of 5149 aspect to it. I know you make some points against that. I'll let John speak to those points.
Okay. I don't think there's a problem in using 5149 as a matter of interpretation. I think that we could sharply distinguish between using 5149 rule to see, well, what does this language mean? The different evidentiary standards actually come into what then should we do? What should we do as a decision maker with this? So, to take the example of judicial review, which of course I have written a good deal about in the duty of clarity, it's not that they suggest that there's a 5149 rule for understanding what the Constitution means. The point is that as part of judicial power and judicial duty, going back to England, there had to be a strong sense that the other actor was wrong before displacing their judgment. And so that's when this heightened standard comes in. First of all, it isn't an original method. It's actually part of the understanding of the obligation of the judiciary under the judicial power. And so the difference is that's about a special requirement for how the judiciary has to act. It might be different, you're quite right, different for other actors, as opposed to what we're looking at. What's just the question of what the language actually is supposed to mean as opposed to what an actor then is supposed to do with that decision.
I just want to add one thing, which I'm sure John probably will not agree with, but on Chris's claim that every state employed this duty of clarity rule, I think that's an overstatement. So what you have when you look at the evidence is you've got certain opinions that will mention this rule. And then you've got other opinions which don't mention the rule. And the question is, what do you say about those opinions that don't mention the rule, right? So, and there's a lot of possibilities. They could be applying it, they could be assuming it, they could be rejecting it. When you actually look at what the opinions do that don't mention the rule, a lot of times they don't seem like they're applying the rule, like they're actually using a 5149. And for the reasons that John mentioned, the fact that you wouldn't expect people to say they're using a 5149, you would expect for them to come forward and explain when they're using a different kind of a rule. To my mind, it's quite reasonable to interpret those opinions which are not talking about this, that don't mention it, as not actually using the duty of clarity. So I don't have a firm position on it, but I don't think it's right to say that all the states followed this. I could talk more about it, but since not really what this paper is about, I'll just put it to the side.